Can you hear me clearly,
Yes,
Prof?
yes, you are audible.
Yeah. We will gonna wait until 9 a.m. and we will gonna start the course, Prof.
Sure. Should we start the course now?
Okay, I will gonna start the course now. So, Assalamualaikum warahmatullahi wabarakatuh. Good morning to all the participants. First of all, let's pray and praise to Allah Subhanahu wa Ta'ala who has given us guidance, help, and mercy so we can participate in today's session of International Short Course 2024 without any obstacles. Second of all, let's giving salawat and salam to our Prophet Muhammad Sallallahu Alaihi Wasallam that has brought us from the darkness into a better life. Before starting this session, I would like to say thank you to our honorable speaker, Professor Vikas Kathuria from PML Munjal University Law School, India, and participant for the enthusiasm to join our course. Before going further, I would like to introducing myself. My name is Saffa Abdullah Abdad, and I will be the moderator for this session. In this session, we will discuss about digital platform and competition law. As we know that the digital platform poses new challenge in business competition, and this attracted the attention of government and competition authorities. Competition in the digital market is very different from competition in the traditional market or offline market. And because of that, the authorities are faced a lot of new things, included business competition violence. So, regarding to this issue, sitting among us, our distinguished speaker, Professor Vikas Kathuria. Good morning, Professor Vikas.
Good morning.
I will gonna introduce you to our participant. So, Professor Vikas Kathuria is professor at PML Munjal School of Law and had the Center on Law, Regulation and Technology, or CLRT. He researches and writes on competition law and data governance. Professor Vikas received his PhD from Tilburg University in the Netherlands. His postdoc worked at the Max Planck Institute for Innovation and Competition, Munich, explored the role of competition law and regulation in data-driven market. Prof. Vikas has previously worked with the Competition Commission of India, or CCI. His research paper has been featured in the international peer-reviewed journal. So, for Professor Vikas and all the participants, I will gonna inform that the presentation will last for 45 until 60 minutes. And after that, there will be a Q&A session. To Professor Vikas, the time and screen is yours.
Thank you so much, Ms. Abdad, and thank you so much, UMS, for having me here. I'm really excited to be here and to speak to the participants of the summer school. So, without further ado, I'll just take you to my slides. Just one clarification: it's 7:30 morning in India, so we have 1 hour for the presentation, and it will be followed by Q&A now, right?
Yes, Prof.
Okay, wonderful. Let me share my screen with you. Is my screen visible?
Yes, Prof. We can see your screen.
Yeah. So, ladies and gentlemen, good morning and welcome to today's session. digital platforms in competition law from ex post to ex ante. I'm not sure how many of you are aware of competition or familiar, but I just take it that some of you know what competition law is. The purpose of competition law is to ensure more competition in the markets because economic theory has proven it time and again that competition is good. Not only prices go down, but when we compete with each other, we get the best out of us in the sense that innovation happens, prices go down, quality improves. So competition is very good. And so this was the purpose of competition law. And competition law is basically exposed in nature. We're just not referring to merger control. It's exposed in the sense that when something wrong has happened, only there the law steps in and says that okay, we need to fix the problem. If anti-competitive agreements have happened in the market, then competition law regime comes in and says that look, this is bad. You cannot be entering into this kind of agreement or abuse of dominant position if somebody has engaged in predatory pricing, exploitative abuses, other kind of abuses, then the law says that something that you have done is wrong and hence you have to pay penalty, fines, or you have to cease doing what you have done. So this is something when the harm has already taken place. But as Ms. Abdad indicated, I will try to show you in my presentation that platforms, digital platforms, why they are different and why they need a different kind of intervention from competition policy perspective, which is not ex post but ex something, some rules that tell us what is right, what is wrong. Even before something happens, the rules say that look, you have to conduct yourself in a particular way. You have to change your behavior to ensure there is optimal competition in the market. So my presentation would be focused on this. This is something which has become very relevant because many jurisdictions, in addition to export, they are also trying to craft and design ex entities. I'll be giving you the reasons and a little bit background about it. Okay, first of all, this is going to be my roadmap. What are digital platforms? What kind of anti-competitive practices take place on digital platforms? What are the existing frameworks? The existing, and I'll try to show you that existing framework, is limited in the sense that it cannot ensure competition in the market the way we understand competition law. And finally, I'll take you to the reasons why we need a new ex-ante framework, example of European digital markets, right, which is sort of a prototype, a blueprint for ex-ante regulations in the world. I'll show you that other jurisdictions, the UK has also enacted an ex-ante framework in the form of P and CC. And in developing countries also, there is a huge movement that they also need an ex-ante framework. I'll give you the example of India, and then I'll wrap up, and then I'll take questions from you. Okay, so if you can see your screen, then perhaps you see so many examples of platforms. You see Airbnb, you see Microsoft, you see Facebook, Uber, Google, definitely. These are examples of digital platforms. What do platforms do? What is the purpose of platform? Platforms, the purpose of platform is that they are intermediary. They make sure that two different sorts of consumer groups meet each other, they interact with each other and transact the business. Say, for example, Facebook. Facebook is a platform. It makes sure that it's a social media platform that different people come together, users, people like you and I, well, most of the young people, they are not on Facebook, they are on Instagram, but my generation started with Facebook. Some of us have migrated to Instagram as well. So the idea is that we stay in touch with each other. At the same time, you have advertisers who target you based upon your preferences, based upon your user data. They get to know that what you're interested in, and accordingly, you are served with relevant advertisements, be it Facebook, be it Instagram, or any other social media channel. So this is the purpose of a digital media, digital platform. Digital platforms, they are more often than not, they are based on algorithmic, they're algorithmic in the sense they are not physical places like markets. where you and I go, we touch the product, we feel the product, we buy the product. No, it doesn't happen like this. This is all algorithmic world. And in this algorithmic ecosystem, what is very interesting is the underlying platform is built on more often than not on artificial intelligence technology, artificial intelligence algorithms. These are the algorithms that become smarter as they interact with data. So as they munch on data, they become smarter, they become more relevant because they understand the user behavior. And what is more important for these platforms that they are always data hungry. They need more and more and more data. The more the data you give them, the better these platforms become over a period of time. That's why you realize that these platforms, they're always in need of more data. So this data serves dual purpose. The dual purpose is that first the underlying algorithm becomes stronger, becomes better. And the second, through this data, people get to these platforms, get to know about their users. They know that, user A is different, user B is different, user C is different, and accordingly, they serve them different advertisement, different kind of offers which are more relevant to these individuals. So I give you the example of Facebook, another example would be Google. You know what Google does, like Google search, like you all use Google search. The more we interact with Google, it becomes stronger because it gets our data, becomes more useful for upcoming users. So this is the example. These are what digital platforms are. Ms. Abdad in his introduction said that digital platforms are a bit different. I'm going to here tell you, like, I don't know who the participants are, but I believe that some of you are not familiar with the concepts like basic economics of the platform. So let me tell you what these characteristics are, which make them a little bit different from the physical brick and mortar world, the way we have understood. Network effects. Network effects are something like which differentiate platforms from the real world, from the brick and mortar world. In the sense that network effects are like the value of the platform increases as the number of people using that platform increases. It's proportional. The more the user, the better the experience becomes for users. Say, for example, I give you the example of direct network effects. The picture to your left, the telephones which you can see, like if there are just two telephone, like I'm not just talking about the mobile phones, but we could take the example of mobile phones as well. If it's just talking about phones, then if there are just two phones in the city, you don't feel like buying a phone. Why? Because you would be in touch only with two people. But if 10 people, if 20 people, if 100 people have phones, mobile phones in the city, the entire mobile phone system becomes more lucrative to you because you would now be able to talk to 100 different kind of people. So the value to the last user, to the new user, and also the existing user increases as more and more people start using that service. For example, Instagram. If you guys are on Instagram, if just two or three of us are on Instagram, they would say that, oh, I'm not going to be very much interested in Instagram because if you just two, three people, I can just knock on their door, have a cup of coffee with them, get to know about them, right? But as more and more people join Instagram, you see that, oh, it has become very much important. The entire classroom is on Instagram, the entire office is on Instagram. So now it has become more useful. All right. And the second instance of network effects is indirect network effects. When there are two different group of consumers or different group of users. I'll give you the example of Uber. It's a ride-hailing service in the sense that it matches drivers with users, the commuters, those who have to travel from point A to point B. Now, if there are more drivers on Uber, there will be more people who would be attracted to Uber. And if there are more travelers who are choosing the Uber application, the more drivers will be interested in coming to this platform. You understand? There is a two-way, feedback loop, two-sided network effects, we call it. Like side A ensures that side B finds the platform more lucrative. Side B ensures that side A finds the platform more lucrative. This is called two-sided indirect network effects. So as a whole, what happens that the platform becomes more relevant, more useful. But this is something which is very interesting. This is something which happens, but at a downside, I wouldn't say it's a downside, but it's a natural phenomenon. The competition gets very much affected because of the very nature of network effects. See, for example, I give you the example of direct network effects related to the phone example we took. If almost 60%, 65%, 70% people are on Instagram, then you do not feel the need to be on the network of Instagram's competitor. Why would you be downloading 2 or 3 different applications on your phone? Even if you download 2 different kind of applications on the phone, more often than not, you will not be using it. Why? Because most of the classroom, most of your social circle is on Instagram. So what happens that the market tips in the favor of the incumbent or the one who has moved in earlier opposed to others, right? Those who move early mover advantages are pretty much there in these markets. Indirect network effects, if say for example, multi-home is not possible, the drivers will find Uber more lucrative because there are a lot many people, all of us are using Uber. Since all of us are on user mode driver, the newer drivers would not be going to the competitor of Uber. They would rather be sticking to Uber. So again, because of indirect network effects, market tips in the favor of a particular platform. It's one platform becomes stronger, becomes dominant, or becomes a monopolist, depending upon other characteristics in the market. So this is something which does exist. This is by very nature of the market, but it poses some challenges for competition policy because competition policy, the task of competition policy is to ensure there should be more competition in the market because as I said that more competition is good, but because of this economic characteristic, it becomes difficult for others to get into the market. Another phenomenon which differentiates digital platforms from brick and mortar platforms is economies of scale. Economies of scale means like as you provide more services, more products, the price of product comes down, reduces. This is something which is very interesting. Like in the Ford company example, up to 100 frame of the car, the cost price keeps increasing, keeps increasing. But as you start making the 101st frame, the price of the frame starts coming down. Why does it happen? Because you are optimally using the supply, the assembly line. This is called economies of scale. So the more you produce, the marginal cost or the average cost starts coming down. Now, this is something very interesting in the sense that if you are catering to a lot of people, if you are manufacturing products in bulk, the prices come down, which is a very good thing for consumers. But at the same time, we need to be mindful that new people, those who want to compete with these incumbents, would find it increasingly difficult to match the pricing behavior. Why? Because this particular point, the QT point which you see, will be very difficult for them to achieve. Why? Because they are small players, they are manufacturing maybe 10 cars, 20 cars, 50 cars, 60 cars, but the economies, sorry?
Man.
So,
Stop run.
So all of you can very well understand that this point Q2 can be reached only by a bigger player. And since the bigger player has already been producing 110 cars where the economies of scale starts triggering and kicking in, it would be difficult for others to achieve that scale. So these two phenomena together make competition in digital markets a bit difficult. It gets a little bit difficult for new people to come and compete with these incumbents. Okay. Now, some examples I'm going to give you of anti-competitive practices like Google Shopping page. I'm not sure if you guys are familiar with Google Shopping page. So what happened that this investigation started, I think started back in 2011, 2010 maybe. So it took 7 years for the European Commission to finally say that this practice was bad. What was this practice? That Google was preferring its own shopping services over that of its competitors. If you see the Google on your phone, if you say that, okay, I need to buy something in Jakarta, right? If I want to buy cameras in Jakarta, I Google it on, I just put the query on the Google. you would expect that Google will tell you the results organically, in the sense that where you can buy these cameras online in Jakarta, right? But what Google was doing, that Google came up with its own shopping services, and as soon as it came up with its own shopping service, its own shopping platform, it started pushing other platforms down the search ranking. So it started preferring its own marketplace over that of its competitors. Now, this was something very interesting. The European Commission used behavioral economics. It used like the very novel theory of harm, and it finally said that look, it is bad. You're preferring your own services over that of your competitors. This is anti-competitive, this is self-referencing, and this is abuse of dominant position. However, I must tell you that it took like 7 years of time for the commission to find out this practice was bad. What is happening within 7 years? Come to think about it. Those people who have left the market in 7 years because these anti-competitive practices, they are not going to come back once the European Commission says that it was a bad practice. Why? Because they are dead, they have left the market. It's increasingly difficult for them to make a re-entry into the market. Time and wonder. Once again, Google Android case. When you buy a new Google phone or Android phone, the Android phone, like because Google bought Android, you see that the Google suite is already pre-installed on the operating system. What does that mean? In the sense that you have Google Chrome, you have Google Search, you have YouTube, you have Google Calendar. Everything is already on your phone. And what happens when you are already given a very optimal service, you don't see the need to look for other alternatives, other competitors to Google. Why? Because you are already using it. And once again, human beings have status quo bias. Now, this is from behavioral economics, in the sense that if you're using something, you do not want to change to others. Change is not good for humans. We don't want it. And why would you change to something else which is not as strong as Google? So what is happening in this case, because of pre-installation, because the operating system, it belongs to Google, Google is tying its other services. Because of this, the competitors are not getting chance to be on your phone. Since they're not getting chance to be on your phone, they are being pushed out of the market. They are not getting the data. They are not becoming stronger. They are not getting the chance to serve you advertisement. Hence, they never find grounding in the market. All right, so this is anti-competitive. Once again, Google was fined 2.4 billion euro, I guess, in European Union. It took 4 years for the European Commission to finally find that it was anti-competitive practices. Likewise, Amazon has been was accused of using the non-public marketplace seller data, and it was engaging in discriminatory practices so far as buy box and prime programs are concerned. I'm not going to get into the details of it, but basically, again, it was a case that you are doing something which is anti-competitive. You're preferring your own services, you are discriminating against others. In this case, as soon as the EU ordered investigation, Amazon gave it commitment that look, we are not going to do it. I'm sorry, we did something wrong. We are not going to do it. Okay. And likewise, we have Apple App Store cases when Apple App Store said that okay, we are charging 30% if you are an app who is using Apple App Store to reach out to consumers, you will have to pay 30%. Remember the famous Epic Game example or the Spotify example. So if you have bought Spotify through Apple App Store, you will have to pay 30% commission to Apple. Not only that, Apple contractually makes it impossible for Spotify to reach the consumers directly. You cannot give cheaper offers to your consumers. It's just prohibited. You have to use the Apple payment system. So through this entire structure, Apple ensures that it keeps 30% of the fee to itself. Now, please understand that if you are making $100, $30 go to the platform. Why? You think that $30 are justified? What are they doing? They are, of course, doing some services. They make sure that applications are not there. They curate, they invest. But $30 is could be exploitative in this case. And you have to understand that what you need, the rents that you reap in the market should be proportional to the services that you bring to the market. But this is, in this case, this is disproportional, the kind of money that Apple App Store is making. And they can do so because they are the platform, they are the dominant platform, they are the only means to reach out to consumers. So these are some examples. And I must tell you that these are the examples which are not specific to the European Union. These examples are manifested elsewhere as well. Like say, for example, in a developing country such as India, it has happened in UK, it has happened in South Korea, it has happened in many, many other jurisdictions. So the jurisdictions are waking up that, look, we have the expose tool, but there are some limitations. What are the limitations with the expose tool? First, excuse me, these tools take a lot of time to kick in. You have to devise, you have to first define the relevant market, you have to identify whether the firm in question is dominant there or not. Then you have to devise a theory of harm, you have to adduce evidence, you have to, and when you come up with an order, it can be challenged again and again and again. So this is something which takes a lot of time, and in this time period, the market tips because of network effects in the favor of those who are doing these anti-competitive practices, right? So even if you say that Google, you are doing something bad, it is not going to have any pro-competitive effects, okay? And the second problem would be in many cases, even though these firms are doing something wrong, they are strong, they are powerful, but they're not dominant in the sense of traditional competition law. They do not have the kind of market share, that requires one to be dominant. Yet they still can manifest this market power and can they engage in anti-competitive practices. I will elaborate on it in some time. Okay, so because of these reasons, because the economic theory says that there is something, these platforms are a little bit different from the traditional brick and mortar market, plus the real cases that manifested in different jurisdictions, the, academic community, the civil society, they realize that there is something fundamentally wrong with digital markets in our competition law structure. We need to make certain changes, but these changes, they would come in only when the theory, when there are strong economic justifications for bringing about the change. And these changes came in through, these reports. What the slide that you see on your screen right now, these are different reports from different authorities in the world that laid down the economic characteristics of digital markets. These characteristics which distinguished, application of competition policy in the brick and mortar from the application of competition policy in the digital world. So there is a very famous report, like the Tremor report from the European Union, the Furman report in the UK. Likewise, there was a report in the in Germany. All these reports, they indicated in the same direction, and the direction was that we need to make certain changes. It can't go on forever. There is something seriously wrong with the digital market, and the tool that we have is a limited tool. It cannot bring about consumer welfare. It cannot bring about competition in these digital markets, right? Because of this, the jurisdiction started waking up. So once again, I just have sort of, captured everything on one slide. Economies of scale, scope, the markets are tipping, they act as ecosystems. So the enforcement is slow, the harm is irreversible. Why the harm is irreversible? In the sense that because of anti-competitive practices, if entity has left the platform, it will be difficult or rather impossible for them to come back to the market. So the competitors, once they leave the market, they cannot come back because the entry barriers are very. Because of this, the jurisdiction started going up with this idea that let's have X and reviews. Even before something wrong happens, we will tell what is right, what is wrong, and you do not have to engage in certain kind of practices. Some examples I'll share with you, the EU-GMA, which we are going to study in greater detail right now. Then we have example from Germany, paramount significance for competition across markets. Germany, instead of coming up with a new legislation, they made amendments to their competition law, the GVP, but on the same lines, in the sense it gave ex ante power to the Bundestag. The UK DMCC is also a similar structure. Okay, now let's get into Digital Markets Act. I'll tell you what this Digital Market Act is. So it was proposed in December 2020. Finally, it was adopted on 14th September 2022, and it started, and the enforcement started on 2nd May 2023. So if you look at the timeline, it was proposed. Of course, it took a while for the European Commission to conceive the idea. Finally, it was proposed, and the enforcement started much later, only on 2nd May 2023, because it gave some time to the undertakings to adapt, to build up the capacity to comply with the law. The objective of this law, the EU DMA, is contestability and fairness. Mind it, it is just not contestability. If you look at competition law, the goals of competition law, even in Europe, it's not like one thing. It's not sure like, it's just consumer welfare or it's contestability. It's very much debated. But we can all say in one voice that the purpose of competition law is to ensure that there is contestability in the market. However, the purpose of DMA goes beyond just contestability and it also touches fairness. I'll tell you what fairness is. The fairness is basically about how the platforms treat or deal with business users, not the consumers, but the business users. Say, for example, you're Amazon and I am putting my product. Say, for example, I'm selling mouse on your platform, Amazon. So fairness concerns me. How you treat the business partner, not the user of this mouse, the one who buys this mouse on Amazon. Okay. Now, who are the candidates for enforcement? These are large digital platforms which are called gatekeepers. If you know who gatekeepers are, the gatekeepers say, for example, to the university, make sure that who enters the university, how they behave in the university, how they act in the university, right? So they decide the rules. These are the rules that you have to adhere to. They become so powerful. The gatekeepers, they likewise in the market, gatekeepers are those ones who decide who will be entering into the market, who will be selling mouse, who will be selling clothes, what will be the condition, what will be the prices, how the marketplace will act in general. So these platforms like Facebook, Instagram, Apple App Store, Google Search, Uber, they have become so strong, they become so solid, they decide what are the terms of engagement for users and for the business users in the marketplace. That's why the term that the gaming uses is gatekeepers. Mind it, this is not dominant position. Dominant position is different. Gatekeeper position can exist below the dominant position. And this is by choice. This is by very much design, because in these markets, the harm can manifest even if you are not a dominant player. Now, this is the third point. Please refer to the third point. This is very interesting because, as I said to you, that ex post, it looks into the conduct. It says that, okay, it could be good, it could be bad, but the ex ante has clearly laid down. Look, this is something which you can do. This is something which you cannot do. Or this is something which you have to do. These are the rules. These are the do's and don'ts. So if you are in a marketplace, you have to adhere to these rules. I'm not going to get into it like, what your practice is, but I'm telling you what you have to do. So I'm not going to judge your practices later and identify whether it was right or wrong. I've already found out what are the practices which are right and wrong, and you have to stick to these practices. So this is the philosophy of ex ante. So even before something happens, I tell you what should happen. Now let me give you some examples. Like, so some examples of obligations, what the gatekeepers have to do. You can see that, these articles 6, 7, and 8 in the UTME allow third parties to interoperate with the gatekeeper's own services in certain specific situations. So if I am a gatekeeper, if I am operating system, the other applications should be able to interoperate with my operating system. Interoperability, like two different systems or two, complementary systems should be able to talk to each other. Now, this is very much important because it increases competition in the market. Allow the business users to access the data that they generate in the use of the gatekeepers platform. Now, if I'm selling my phones on Amazon, then Amazon has been obligated to share the data which my services have created. Amazon, just because it's the platform, cannot get to keep the entire data to itself. It has to share the data with its business user, which they have generated. Likewise, there are other obligations as well. You can go through it, you can have access to the slides so that you can study in detail. My purpose is to just tell you that certain similar obligations have been cast upon platforms, the gatekeepers platforms. Like there are certain things, they cannot do anymore, these gatekeepers, like prevent consumers from linking up to businesses outside their platforms. Like I can have different kind of, if I'm Apple App Store, I cannot be the only means from where you have to buy apps. You can buy application from direct web page of that particular app store, particular application. So that means that if I have to download Spotify, Apple App Store is not the only gateway. I can go to the web page of Spotify and I can download it. Okay. Another prohibition is that you do not have to pre-install software. You're not allowed to pre-install software on the operating system, like the Google Android case. Remember, I told you about the Google Android because everything when you buy the phone has been pre-installed. Now, this no longer can happen. This is specific to EU. So these prohibitions and obligations have been passed upon gatekeepers. And remember, what is the idea behind these obligations and prohibitions? To ensure there is proper testability in the market and there is fairness in the market. Like when I say that the platforms have to share their data with business users. Now, this is about fairness because they have to treat their business partner with fairness. Now, a law is useless if you do not provide for penalty for non-compliance. If you guys are lawyers, most of you are the policy people. If I just say that, look, this is something you have to do, you do not have to do. I can be a preacher, I can be somebody who comes from a moral standpoint, but you know that in the marketplace or in general, law has to have the force of the sovereign. In the sense, if you do not comply, you will be paying fines. You can be penalized. So what are the fines? 10% of the company's total worldwide annual turnover, or up to 20% in the event of repeated infringement. So these are huge fines. If you do not comply with DMA, you have to pay up a lot of fines. Periodic payments. If you are not complying, like if you're not furnishing reports of compliance, 5% of the average daily turnover you give every day to the commission. There are other remedies in case of systematic infringement, like once, twice, thrice. If you keep engaging in bad behavior, if you're not complying with the DMA again and again, then you can be met with serious consequence. And what is the serious consequence? That the European Commission can also break up your company. It's a huge remedy. It's a structural remedy, which gives enormous power to the European Commission. It says that, okay, I have laid down rules. I'm willing to talk to you. I'm willing to tell you what is right, what is wrong. I'm also willing to pay fines in the beginning if you're not able to comply. If you're not complying, then I'm going to impose fines. But eventually, if you're just not listening to me again and again, in case of systematic infringements, then you will be met with the supreme penalty, and that is breakup. I will break up your company, and nobody wants that in general. So it means that DMA is a strong piece of legislation. You comply, it's fine. If you do not comply, the consequences are going to be enormous. So that means the DMA and the European Commission, they are very serious about this piece of legislation. Now, as earlier now, as recent as 25th March 2024, The European Commission has already opened non-compliance investigations against Alphabet, Apple, Meta under the Digital Markets Act. So the enforcement started 2023. Some firms were designated as gatekeepers by the European Commission. They were designated gatekeepers. I do not have it on the slide, but there is a framework. There are quantitative and qualitative thresholds. So if you satisfy those quantitative thresholds, if you are big beyond a particular size, you will be determined to be a gatekeeper. So not everybody, not all platforms are gatekeepers. Only when you have monetary power or when you can reach out a lot of consumers can then be determined as gatekeeper. Not all platforms, right? Only bigger, solid platforms are gatekeepers. So last year, the commission designated a few platforms as gatekeepers. So the moment they were designated as gatekeepers, they have to comply with the law, comply with the DMA. And those who have not engaged in compliance, like Alphabet, Apple, and Meta, investigations have already been started against them. Within 6 months, the commission has to finish this investigation, and then they have to find out whether they have actually violated the law. And if they have violated the law, you can see that they will have to pay a fines. All right. Now, I come to India. I'm from India. I've been working in India. So I'll tell you that what has been India's approach. And also I found it very interesting or important to share the Indian experience with you because many people think that it's a first world problem. Competition or anti-competitive practices in digital markets. Indonesia, India, countries in Africa, these or Brazil for that matter, we are emerging markets. Our markets are very small. We don't have to have this kind of onerous ex-ante legislation. We just don't have to worry about it. But I want to share with you here that that's not true. These kind of practices are manifesting in India, in our jurisdiction. I'm pretty much sure in Indonesia as well. And why a developing country should also have this kind of ex-ante framework. Now let me show you some data about the internet users in India. They are second highest after China. Smartphone users, one of the highest in the world. E-commerce users, they are like fastest growing e-commerce market in the world, India is. Social media users, they are only second highest after China. So you can see that the Indian digital markets are very, very much important. They are very much relevant. If you know the population of India, we are 1.4 billion people. So you can imagine that it's such a lucrative market. And because of the government schemes, the internet penetration has increased quite a lot. And we can, and as you can see that a lot of people are using smartphones, and smartphones have become the main gateway to using internet for most of us. Right? Now, since it is such an interesting market, there are local startups as well. These people who want to make money out of digital markets. They have small startups, who are trying to use these platforms to reach out consumers. All right. And here I just show you very quickly that the practices that manifested in the EU in some way or the other, they have manifested in India as well. Like we had this case, Amazon case, like 2020, where Amazon was accused of, engaging into or entering into anti-competitive agreements, arrangements, and it was accused of violating the principle of platform neutrality in the sense that it was favoring its own entity over that of others. So what happened in these cases? The Competition Commission of India, unfortunately, could do nothing. It could do nothing, even though these were anti-competitive practices. The local people, like local startups, were getting affected. They could not act against Amazon because Amazon was not dominant in the sense of ex-post competition law. Again, like something very interesting, there was a Reuters special report on Amazon. So Amazon was accused of copying the product of a shirt maker. It was accused that, it copied the product of a shirt maker. It copied the size, the texture, the look of that shirt, and came up with its own white label product. Not only did they steal the data and came up with its own product, Amazon also threw that particular brand, like John Place, it was on page number 2 or page number 3. These are the places where nobody goes to. You and I, we both stick to page number 1 if we have to make certain purchases. Again, this is behavioral economics. We do not go and search for page number 3, 4, 5, etc., when we have to make certain choices. Now, this is something which you can see that it's a clear case of self-referencing. Imagine the consequences for John Players. Imagine the consequences for any other product whose data has been stolen, whose product has been stolen and copied by Amazon. Nobody's going to buy them because for Amazon, it's much cheaper to copy the product than come up with their own product. So they will definitely leave the market. Their sales will go down. There's a clear case of anti-competitive activity, but in this case, again, the Competition Commission of India could do nothing. Why could do nothing? Because once again, Amazon was not dominant because we have another competitor of Amazon, which is Flipkart. Their market share is similar to Amazon, but as you can see that they both are gatekeepers in the sense of ex-ante competition law, ex-ante framework, but ex-ante framework was not present in India at that time. Likewise, as I said that, in Europe, Google was accused of self-referencing. Same fact, same practices Google was doing in India also. In India, again, like 22.2, it was fined to the tune of 20.42 million euro. In the case of Google, this Android example, which is another case of pre-installation and self-referencing, again, this thing also happened in India. The same facts manifested in India, and again, the Competition Commission India, after a long investigation, fined Google. So, same things that Google was doing in Europe, it was doing in India as well. Again, there are so many other examples where they were engaging in anti-competitive activities. WhatsApp, what was WhatsApp doing? WhatsApp said to its user that, look, if you want to keep using WhatsApp, you have to agree to us using your data for Facebook. To use something to share their data with the Facebook company, like, to the other Facebook companies. If you're using WhatsApp, your WhatsApp data will go to other Facebook, products. Now, this is something which is bad because Facebook can't do it. WhatsApp could not do it if it was not dominant in the market. It was not a gatekeeper because they were powerful. They could impose such kind of restrictions, right? So once again, these things have started happening in different jurisdictions. They are happening in India. They are happening in Brazil, in other developing countries as well. That's why I think developing countries have to wake up. Why do they have to wake up? Because it's the consumers who are getting affected because of these anti-competitive activities. These are Indonesians, these are Indians, Brazilian startups, small business who are using these platforms and want to reach out to consumers. They are getting affected. Imagine, like, if an Indonesian startup, like a phone manufacturer or like or like a shirt manufacturer, came up with its own product. Once it became successful, Amazon stole the data of the product, came up with its own product, and threw this shirt company to page number 2 or 3. It's not good for our businesses either, such kind of practices. That is why, the Competition Commission of India realized that our ex-post powers are not enough. We need something else. We need more powers. So, and in many communications to the government, to the OEC, CCI acknowledged that the ex-post pool is limited and we need some power. We should be given more power. So the government woke up in 2022, December 2022. It constituted a standing committee to look into the anti-competitive practices by big tech companies. So this report finally came up with its recommendation, and it said that, look, there should be an ex-ante framework. There must be an ex-ante framework, and the government, February 6, 2023, constituted a 16-member interministerial committee, CBCA, to propose to look into it more closely, the kind of activities of big tech players, and propose whether there should be a bill or not against such activities. So finally, in March 2024, this year, right, March 12, 2024, the CDCA committee came up with a huge report. In this report, they said that yes, the competition law tool is limited, the CCI is struggling against these big tech companies, and there is huge loss to welfare, and hence we need an exemplary framework. And towards the end of the report, it proposed a bill. You know what a bill is. So once it is passed in the legislature, it becomes a law, it becomes an act. So this bill is draft as of now. India is discussing, debating this bill, and hopefully someday it's going to see the light of the day. I will just tell you the principles now. This is the last part of my presentation. I will be just telling you in the next 5 minutes the structure of the digital competition bill, the Indian digital competition bill. Now, it has been crafted more or less on the lines of the DMA, the EU DMA. The principles are contestability, fairness, and transparency. And the objective is to foster innovation and promote competition and definitely consumer interest as well. It says that big companies, the large digital platforms, are systematic. Some of them have become systemically significant digital enterprises, SSDEs. So instead of using the term gatekeeper, they use the term systemically significant digital enterprises, SSDEs, that provide core digital services. What are these core digital services? Like Google Search is core digital services. Virtual assistant is core digital services. So they have become gatekeeper with respect to core digital services. And these are the services which are prone to be tipping. All right. And as of now, there are 9 entries in these 9 such core digital services. Just like the DMA, the Digital Competition Bill India has quantitative threshold. It says that, okay, there is a cumulative test, quantitative test, and qualitative test, significant spread. So even if you do not satisfy the quantitative, if you reach out, if you can reach out to a lot of people, that means you are big enough. You are in a position to influence markets, and hence you can be designated as SSDE. There can be exceptional cases as well when you are not satisfying the quantitative threshold. And in this case, based upon certain qualitative criteria, the CCI can designate you as an SSDE. So finally, once you have been determined to be a systemically significant digital enterprises, you have to adhere to certain obligations and prohibitions, just like the DMA. So the Indian competition body, the CCI, will be the watchdog, will be the regulatory agencies to enforce this ex-ante regulation. All right. So this is the list of core platform services. You can see on the left-hand side is Digital Market Act. On the right-hand side is Digital Competition Bill. So the only difference is the virtual assistants. The list is exactly the same, with the exception that virtual assistants do not feature in Digital Competition Bill. Certain conducts has been prohibited. They have been asked to act in a fair, non-discriminatory and transparent manner. Certain things have been prohibited, just like TMA prohibits self-referencing. You can look at these obligations which feature on the slide there. They have been just taken from the bill. These are the rules that these SSPs have to comply with. All right, prohibition on tying and bundling. So basically, I don't want to walk you through these obligations in detail. My idea is just to tell you that once you have been designated as an SSDE, there are certain things which you can do, which you have to do, and there are certain things which you just cannot do. They have been prohibited for you. All right, and then I don't know again take you to the nitty-gritties. So the idea is that the CCI will be the enforcer. There are settlement and commitments also. So if the investigation has been started, you have been designated as an SSD, there is non-compliance report, investigation against you, you can give commitments to the Competition Commission of India that, look, we won't be doing these things. There are interim measures as well, like before the investigation gets over, the CCI can say that, look, in the interim, you cannot do certain things, right? So just like DMA, the DCB is also following the same kind of principles to ensure that there is optimal competition in the digital markets, for which for now do not have robust competition. So this is the framework of digital competition bill. My idea was to give you the basics, the broad principles, rather than taking you into the nitty-gritty, because that would become too complicated. I have my email address. You can reach out to me. You can write to me, so that if you have more granular questions, I would be very much happy to answer these questions to you separately. Thank you so much. I stop here, and then I'll be very happy to take questions from you.
Okay.
I'll stop sharing my screen.
Yes, Prof. You can stop sharing the screen. Thank you so much, Professor Vikas, for giving us such an informative and interesting presentation. Now we will kind of moving on to Q&A session. In this part, we will have two sessions, and for one session, there will be a three question. So for everyone, please type your question in the chat box or use the right hand feature to ask the question directly.
If you have found the presentation to be a bit too technical, you can ask for clarifications now. I know that, this is technical, but this is something which is needed. Previously, lawyers would study simple laws. I wouldn't say they were simple criminal law, competition law, intellectual property, and they would employ these things, right, into day-to-day practices. But the markets have become too complicated. There's a lot of economics, business principles that they have to study. So interdisciplinarity has become the norm. So I'm sorry I can't simplify it even further, because this is the reality. And I know that my Indonesian friends will also be using these principles in the future. But if you haven't been able to understand something, please ask me. I will try to simplify it even further.
Yes, Prof. Now we have one question in the chat box. You can read the question by yourself, or I will kind of read it for you.
No, Ms. Abdad, I can see it. Thank you so much. So the question is from Mr. Alamgir Hussain. How can competition authorities effectively identify and designate new gatekeepers as the digital landscape evolves? Thank you so much. It's a very good question. It's a very good question. You see, the gatekeepers, they have been identified based upon certain quantitative threshold. Those who could satisfy the threshold were designated as gatekeepers. But there is nothing which is set in stone. There can be new players as well. It's a dynamic market. They might not satisfy the threshold as of now, but in the future, they may become big. They may become big, and after a market investigation, it's a self-reporting. You have to keep reporting your revenues. You have to keep reporting your turnover to the commission. And if you think that this turnover has gone beyond a particular point, then you have to tell the European Commission that, look, we are in compliance, we are satisfying this threshold. And based upon that, the commission can say that, yes, you are a gatekeeper. All right. And so this is dynamic. It is not set in stone. There will be more and more gatekeepers that will be coming up. Okay. Hi. And then we have another question from Azra. Hi, Professor. I want to ask, how can the implementation of ex-ante rules affect innovation and competition in digital markets? Once again, it's a very good question. Thank you so much for this question. Look, those who support this ex-ante framework, they argue that competition is a means towards innovation. This is economic theory. When you compete, and especially in digital markets, or like those markets who are characterized by innovation, you are forced to come up with innovative products. People don't care much about prices. In any case, these markets are free in most of these markets, digital markets. But what happens that you compete on newer products, newer services, etc., etc. So those who support, this is what they argue. But those who are against this kind of framework, they say that, look, if you are imposing these things, it will disincentivize these big platforms to make investment in the market. They will not have enough money to invest in newer products, in innovation process, etc. Now, this is an argument which is not a good argument, which is not very convincing in a sense, because if you think from the standpoint of a common consumer, you and I, we are the ones who get affected. The example which I gave you, the short example that Amazon was taking the data, or rather stealing the data, came coming up its own white label brand and throwing this short company to page number 2 and 3. Who was the one who was getting affected eventually? It was us. Because if Amazon starts doing it with everyone, starts stealing their blockbuster products, nobody would be willing to come in the market. Nobody would be willing to invest in newer and better products because they would know that Amazon is going to steal it anyway. These are the common people who are getting affected. So this idea that investment would be stifled, no. I agree that they have to spend a lot of money in compliance, but that's the reality. And mind it, not everybody, small platform, small market players, they don't have to be in compliance with ex ante framework. It's only the gatekeepers. Those gatekeepers who have deep pockets, those who are powerful, they have the money, will be complying with this framework. So I do not buy this idea that investment and innovation will be stifled in these markets. Do we have more questions now?
Yes, for all the participants, we have one question in the chat box, Prof.
Yeah, we have from Halima. If the digital platform competition violated, what is the remedy? Thank you so much, Halima, for this question. I had it on my slide, so let me make it very clear. As I said to you that these rules, if you violate these rules, there would be penalty. As I said that the penalty is like it can go up to 10%, 20%, and if there is a regular non-compliance, 5% of the daily turnover. In case there is a systemic non-compliance, in the sense that a platform is continuously violating it, then it can also be broken up. There is a structural remedy. There is a provision for structural remedy. It can be broken up into pieces. Now, this is something which is very powerful. And that's why these gatekeepers would be scared of this framework and would be compelled to follow it, to comply with it.
Thank you so much, Professor, for answering the question. To all the participants, we still have a time. If you need anything, question to ask to Professor Vikas, you can do it by sending your question in the chat box or use the right hand feature.
I don't see others asking questions, but in general, I think it can be a very interesting topic for those who are interested in competition law, market laws in general. And I know that it's a new topic. Not many are familiar with it, but this is something which is state of the art, which is something very recent in the realm of competition policy. And those who are interested in competition policy, they are dedicating their attention to it. If you want, you can ask Ms. Abdad, she can share the slides. I will be very happy, to share my slides with you. It can form as a basis for your further work.
Yes, Prof. So for all the participants, you still have a time to ask a question to Professor Vikas, or you want to discuss something that was okay?
Yes, you can take me back to my slides and say that, okay, this is something on which you want further discussion, that would be fine. Because I try to simplify many things. I haven't gotten to the nitty-gritty. I left out certain things on purpose because I don't want to complicate the discussion at this stage. It is just a primer for you to understand the problem and to appreciate the solution that has been brought brought up in the form of DMA and the DCB in India.
Yes, Prof. There is one question in the chat box.
Yeah, we have a question from Majla. What is the procedure technology industry players view the shift from exposed to executive rules in competition? Again, a very interesting question. You see, of course, there are voices who are opposing it, and there are voices that are supporting it everywhere. We talk about Europe, we talk about India, or about any other jurisdiction. Those who are big tech firms, those who are SSDs, or those who are gatekeepers, they would definitely be opposing it. Why? Because any regulation has a cost. I come up with any law regulation, it will say that I have to comply, I don't have to do certain activities. So there is a compliance clause. Not only compliance clause, if I say that I have to, you have to share your data with your business partners, you have to ensure that the applications can directly reach out to the users. That means I won't be able to charge 30% or 40% or any kind of percentage. I would be losing out on revenues. I would be losing out on data. And these things are very important so far as my profitability is concerned. My profitability will go down. And you know that human mind responds to incentive. If I say that, look, I'm going to take your money, you will not be happy with it. So these large digital platforms, the SSDs and gatekeepers, they will definitely be opposing it. But at the same time, the small players who are using these platforms, like the example, the shirt company, like the example of these, application makers, the likes of Spotify and Epic game creator, right? They are supporting this legislation because it ensures that there is contestability in the market. Small players who want to compete with the likes of app stores, want to compete with search engines, they would be welcoming it for them. The playing field would be level. There would be more contestability in the market. And at the same time, who will be supporting it would be you and I consumers because we get to benefit from this kind of structure. So the civil society organization, the consumers organization in Europe, in some other parts have also supported this piece of legislation. And certainly academia, we academics, we don't have any allegiance, we don't take money from big tech. We don't take money from anybody. We base our assertions, our, research on principles. We look into the economics, we look into the business practices, and we make these kind of recommendations. So these are different stakeholders as of now who are engaged in this debate. So there are definitely different voices, and that is why I want my students, my listeners to be aware of the problem first and then aware of the solutions. It might not be the best solution, but at least we have something we can look up to and it can be fine-tuned later as we go along. Okay, we have a new question. Hello, sir. In your opinion, does competition on digital platforms in the world currently comply with international legal standards? Thank you. I'm not sure if I've understood it correctly. International legal standards, look, we are in the realm of competition law. Competition law is municipal in nature. It's not like intellectual property. It has not been made part of international documents like TRIPS. So it is municipal in nature, but every country, Indonesia, China, India, Brazil, Germany, they have their own competition regimes that ensure that there is optimal competition in the market. So no matter what jurisdiction you are looking at, they all say that there has to be optimal competition in the market. And since there is no optimal competition in the digital markets, that's why they all are going with this idea of ex ante rules. So I hope I have answered your question. This internationally good and DMA, the digital market in Europe, what happens? People call it, the Brussels effect. Whatever Brussels does, everybody in the world follows it. I say that it is not necessarily a bad thing. It can be a starting point, but at the same time, legal transplants should not work or they do not work. So that is why your task as an Indonesian researcher or a student is to see to what extent you can adapt the DMA or any other framework in the Indonesian context. This is the task of academics. Okay.
Okay, thank you so much. So there is one question remain. For anyone who wants to ask, once again, you can text your question in the chat box. Okay, Prof, I think there is no one who wants to ask question anymore. So I think that was the end of our session. Once again, I would like to say thank you for Professor Vikas for the amazing presentation. It's really insightful and we really appreciate it. And we hope that this session will improve our knowledge. Thank you so much, Professor Vikas.
Thank you so much, Mr. Abdad. Thank you so much, UMS, for having me here. It was very interesting. It was a very interesting conversation in the sense that first I cannot see my audience. I don't know who they are, but I just assume that the students, some of them are not familiar with this structure. That's why I chose this topic because this topic is extremely relevant. Because, ladies and gentlemen, you and I, we live in an age where brick and mortar businesses are shifting to digital markets. We all are making purchases online. After the COVID pandemic, we realized that the Zoom platform, Google Meeting platform was the means to reach out to people. We were in touch. The messages, now they take place on Instagram, right? So that is why I wanted my students to be very much familiar with this structure, which is going to affect the lives of all of us. Thank you so much. If you have any questions, you can reach out to me. I'll be very happy to answer the question.
Okay, thank you so much, Prof. You can leave the Zoom if you want.
Yes,
And
I will be dropping out, and I wish you a very good day ahead.
yeah, okay, Prof. For all the participants, as we come to the end of our session, you can fill the attendance list that appear on the chat room. We also saying thank you for all the participants for joining this session. And for a reminder, today we still have another session with different speaker. It will start at 1 p.m. in Indonesian time. Lastly, I would like to say sorry if there is a lot of mistake. Thank you so much. Wassalamualaikum.